Bill Mason, Greenbrier.
Jerry Hayes, Paris.
Ronnie Tickle, Memphis.
Keith Whittington, Johnson City.
Cindy DeBus, Knoxville.
Randy Chase, Nashville.
Thank you. Do I have a motion to adopt the agenda?
So moved.
Second.
All in favor?
Aye.
Let's move to the hardships.
Move to approve the hardships.
Second.
All in favor?
Aye.
Okay. Transcript review. We had the transcript for May 23rd and June 27th. Do I have a motion to approve?
We'll have the one for June 27th back from the court reporter. So right now, just for the May 23rd.
Do I have a motion?
Motion.
Second? Do I have a second?
Second.
All in favor?
Aye.
Moving right along. License approval waive files.
Move to approve.
Second.
All in favor?
Aye.
Interviews. We have some interviews start from the left. Mark?
Had one felony that occurred in 1990, spent some time in jail, was on probation until 2000. He wants to start a residential building construction business, and he's been clean ever since 1990. License number 71300, and I'd recommend approval.
Second?
Second.
Yep. Okay, we do them all at once. Well, I'll tell you what, we'll do them all at once. Is that all right with y'all?
Yes.
Unless there's one that needs separate consideration.
Okay.
All right, that's fine. You want to do mine? All right, I have four. HI's Home Improvement 6334, Unique Crete Designs, had a job over the limit, recommended a $250 civil penalty. Home Improvement 2623, RL Gant Construction, a job over the limit, recommended a $250 civil penalty, and then approval after on both of those after that's paid. 6906 Home Improvement, rebuilding Mendoza houses. Had a question of a job over the limit, but after interviewing him, I could reasonably think that that were separate jobs, so I recommend that it be approved without any civil penalty. And then Contractor 71393, Chris No, who had a felony from 1983, attempted murder, and 1988, possession of stolen property. I interviewed him at length. He's since married, had children, became a single parent after his wife died, has a pretty solid record of construction work in another state, and I recommend approval of that license.
Thank you. Jerry?
Okay, I've got two. One is 71367 for BCA. A felony during his time. He's been off of a number of years. I got 59586, which is a reinstatement. He had a record. I recommend approval of both of them.
Thank you. I have several. I have license number 71366, asking for a BCA license. He was a felon, and he's been clean since 2006, and he's asking for a monetary limit of $43,000. I'd like to approve him. License number 70971, asking for a BCA small b license. The reason why I'm bringing him up, he had a home improvement license that over a limit in Knox County. He went over 4 times, but they were very small $4,600, $4,000, and this $12,700. One for $23,000. They have since gone and got their license for BCA B small, and asked for $170,000. They didn't realize what they had to have in Knox County for some reason, but I feel like if they'll pay $800 fine, I think we'll be all right with them. The next one, Bob's Home Improvement. It's 15696. This poor guy has been trying to get his license, and the state has him the Department of Revenue had him what was it, Mob's Home Improvement, and he's been trying to get everything straightened out with them as well as us. He had a license, and he let it expire with us. It's been 15 months, but he just got married, and his wife came with him, and they've had a lot of problems, death of his mother and everything. Bottom line is that I think he deserves to get his home improvement license back, and he did one job over the limit for $1,500, so I'm asking for a fine of $150 and give him his license back. And we told him that he has to go to the Department of Revenue to get his other problems squared away, that Kathy didn't know how to handle that. The next one, I have a felony. This was at possession of cocaine in 1989, and of course he's been clean ever since. He's asking for a audio vision license, $200,000. This gentleman was in Alaska right now. He's on a trip with his family in Alaska. He flew from Alaska in here to get approved.
What's the license number?
I'm sorry. 71193, and I'm asking for approval for him to get his license. All the way from Alaska back here. He didn't know that he could have probably rescheduled, but he wanted his license, and he's a very nice gentleman. The other one, we have a felony, license number 8606, 1993. It's illegal gambling. He's been clear ever since. He wants a home improvement license. Basically, what he's going to do is just work on his own property, rental property that he has. He's out of Knox County, and he knows he has to have a license, so he wants to be legit. And I'm asking to prove all these.
I've got 3 or 4 here. The first one is home improvement license. On the application, the applicant listed one job that was over a limit. I'm recommending approval with a $250 civil penalty. That is license number HI 5422. The next one, Countrywide Construction. This one had a felony. It was for wanton murder. Evidently it was a DUI case. He ran over a lady operating a vehicle while he was intoxicated and didn't know what he'd done, went home, and they put him in jail. He since served his time, had his sentence commuted. He was convicted in 2006, so I'm recommending approval. He was asking for a BCA B, and I will not approve the B because of experience. He still wanted roofing, so I included a BC 21 in there because he wants to do commercial roofing. $400,000 limit instead of the $922,000, but I'm recommending that approval. Another one that I interviewed 2 months ago for a BCA, lack of experience. The only experience the applicant listed was 2 personal residences. Tried to work with her and get some inspection reports back from that last interview and got those, and some of the inspections brought up some lack of knowledge issues for me. So I've recommending denial of issuing this license. Have one other one, and I think this applicant is here with us. It's license number 71355. It's Gregory Bridwell. We've got an applicant here that's got experience listed. Got a home improvement license now. The experience he listed was from 1983 and 84. There was a job here in 13. He couldn't remember the name of the company that he was working for, but he was the assistant project manager. Did another job last year at the Atlantic Air and Nashville Airport. That was a $425,000 job. Then we have another supplemental page of jobs that were listed. One of them was in 1986. Another one was in 12, 13, 14, 15, and 16, all of them under $25,000. I recommended approval, but instead of the $622,000 limit, recommended only $350,000. Now, he's here to contest that today, and if you'd like to speak and address the board to that issue, now's the time to do it. Just step up there to the mic.
Keith, did we also want a guarantee agreement or bond because
Yes,
of financial?
we decided, since I called Bill in to discuss the case with me, he agreed to that limit, but we also needed a personal guarantee to go on to supplement the financial statement
Of the $350,000.
for the $350,000.
Okay.
A bond is what you said.
Either a guarantee agreement or bond.
I mean, I grew up in the construction business. I got my remodeling license. I don't think anybody remember in '91, you had to pass the test. And I studied for 2 months and passed the test. And then a couple months later, no one else could pass it. I don't know how many passed. They said, no one can pass the remodeling test, so we're getting rid of that. So I've been doing jobs and working. I don't understand, you know, I did jobs when I was working with my parents and all up to $450,000. I oversee the job at the airport, which was over like 420-something thousand. I forget the exact amount. We did everything out there, drywall. We didn't do the paint. We didn't do the carpet. I did the golfsmiths. Has anybody been to the golfsmith in Chattanooga? We did everything there except for overseed it and subbed. We did everything except for this, again, the paint, the electrical, and the carpeting. We built 3 giant simulators. We did demo out there. I started in the construction business when I was 11. I was cleaning bricks for a penny a brick. I've been a foreman on a framing crew, framed houses up to around 5,500 square feet. There's lots of people who don't have near the experience, and they got more financial experience, but as far as construction, it's hard to find someone that's, I've been in the gas pipeline business. I've been a foreman on a leak crew. I've worked with bell holes. I know how to find underground cables. I have extensive experience, and they're not even offering what the job I did last year was $400,000. The median price of a house in Nashville now is $332,000. I mean, which I'm not asking for something that's unreasonable. I'm not someone that hasn't been around this and done everything. I did a job for some people that work for Fridays, and they asked me, they said they had something. I said, what am I saying? I can build anything. And they said, well, we need someone to make giant pool balls. Well, I ended up going on and building $300,000 worth of giant pull bars for Fridays. Even if, no matter how much experience you have, and he goes back to this stuff was too old, if you graduated in '87, you had a college degree, you wouldn't throw out the college degree because it's too late. I remember everything about those jobs. The biggest one was real easy. All I had to do on that job was, I was subbed out, was a built-up roofing. Main thing we had to do is make sure that we kept up with our federal fair wages. That was the hardest part about that job. It was a real simple job. The marina was an extremely difficult job. We couldn't, it was after the hurricane, no one could get a big enough crane. They said it couldn't be done. I didn't sleep for a week till I figured out how to do it. I do jobs all the time. When I run into something I haven't done before, and it's more and more. They got newer, lighter, easier, faster stuff. When you get a new product, I don't sleep. I know people that sleep all the time. I had someone call me recently about a job. They had a big giant mess, and he said, "What caused this?" I said, "Because the guy was doing it. He never did it before, and he could sleep at night." I don't sleep till I figure it out. And I've been a contractor for a remodeling contractor for 26 years. None of you know me. You've never had anything come up here about me. Never been mentioned. I've been here for a long time. I've lived in Nashville most of my life. I'd say 40-something years. I've done everything, and it's a little upsetting for someone to not think I have the experience when I've done this my whole life. And
The question here is about financial limit.
No, that's not.
It is. The question, I'll tell you what the question is. You're asking us, we're going to give you a license. The recommendation is to give you a license. The question is whether or not you get a license for $600 and how much?
I believe.
$652,000 or $350,000. Even with $350,000, you have to have a guarantee agreement or bond because you don't have anything but cash assets in your business. So the question is, you're asking us, we're not saying you don't have the experience to get a license. We're willing to give you a license. The question is, do we want to give you a license with a $350,000 limit or a $650,000 limit? Now, the recommendation has been made by our board member, and I concur, that considering your cash assets and taking your experience into account as well, that $350,000 is a reasonable limit. What usually happens in this kind of case is you get your $350,000 limit, you complete a few jobs, and then you can come back and demonstrate both your financial responsibility and your ability to do the jobs and raise your limit. I don't think that's an unreasonable approach to have. So the question is, do we give you a license with a $350,000 limit based on a guarantee agreement or bond, or do we give you one for $650,000? And so why should, I don't think that the recommendation of $350,000 is unreasonable for this.
That's not what I was told an hour ago. I was told the financial was set because of my experience. He went on about how old my experience was. Again, on the financial, I go to my accountant and we work up a plan according to your rules, and we come.
Financials were set based on the amount of the experience. You had 5 jobs listed under $25,000.
Exactly.
It wasn't the question of your experience. It was the financial amount of your experience.
I'm not sure.
You haven't shared that opinion since we started.
I'm sure I don't quite understand the distinction between the two.
The distinction is, if you did a $25,000 job typically, and now you're asking for a $100,000 job, just to make everything easier, you're more apt to get to $100,000 than $25,000. But based on what you have shown, $25,000 is the jobs that you've been basically doing on what you showed. So therefore,
but I've subbed some jobs and overseen some different jobs for more amount, and I have experience with other companies.
But overseeing the job doesn't make you financially responsible for the job, sir.
I was financially, I owned 25% of the company when I was down in
That was a family business back in 1983.
I'm not disputing that. Again,
that's why I based my decision on what I did.
What you can do, if Mr. Mason, Mr. Whittington is offered to say, okay, we're going to give you a $350,000 license now, and then in a couple more months, when you do a job or something, you can come back up and with your financial statement and be stronger on your financial statement and have done a job in the, let's just say, $250,000 range, and then submit, and then you can get a higher.
I set all this up, went to my public accountant, certified public accountant, and we did everything and put the financial statement in, and to what she says, I qualify for $600 and something thousand.
It doesn't matter. That's not the point. The point is, do you want to settle for $350,000? Would you like a license for $350,000? And will you have a license now? Would you be satisfied with that? I mean, we're going to call for a question in just a minute. We're going to call a question, and we're going to vote.
And again, everything as far as my financials, as far as the way everybody reads the thing, I qualify for more than that.
Well,
and I don't understand if I had. You don't say how much more do I need? I mean, if it was different, we would have put different amount of money in the bank to do what we needed to do.
Well, we've had lots of folks come in here with really good financial standing, but with very little experience. And just because they qualify to do $1 million job does not mean that we're going to just automatically.
That's the case.
That is definitely the case.
I've been licensed for 26 years in the state of Tennessee, and I have not had one. I had one board hearing, the contractor board, which I won, and the whole time I've been here and been licensed. And one of my recommendations is the assistant director of codes. I think I'm as a strong candidate as just about there is, and his experience and everything else. I've never had a job that wasn't finished.
Well, one reason we're asking for a guarantee agreement or bond is because he has primarily cash assets. It is within discretion of this board to decide what's financially responsible and what he qualifies for. That he has more cash than that in the bank is irrelevant to us. We have to determine what's a reasonable limit, and with primarily cash assets, we're still willing to give him a $350,000 license, but he has to do either guarantee agreement or bond to qualify for that. So even with that lower level, he doesn't have assets other than cash under our procedures and rules to qualify.
I want to go ahead and I appreciate you coming to
Let me just get one clarification, and maybe I'm wrong, because I just studied and took the test and studied for a long time, and my understanding is that you can get a license for 10 times your statement. Your quick cash statement is the thing they use, the words they use. And then we get up here, and this is where I'm not quite understanding everything, is that you're offering me half, and then of the half, I have to sign a personal agreement. I understand signing it for $600 maybe when you get close to the thing, but now you're offering from less than half. Well, with $350, it's say half, and you still want me to sign a financial guarantee. Is the 10% not what it says? Is that not what the board, is that my understanding? Am I incorrect in that?
Yes, but it does say that if it's a cash-only statement, you have to provide an indemnity agreement, such as
I'm willing to
guarantee.
do that, but you're not willing to do it for the amount that I qualify for.
No, we decide what you qualify for.
Well,
either it's 10 times or it's not. I mean, am I wrong?
It's in the discretion
of our board. I appreciate you coming and talking right now. We'll go back and have a seat. We'll discuss again shortly. Can we table this one right now and let's move on?
That's all I have.
Okay.
Table it.
Well, if we're going to approve everybody, and then you come back to this one, is what I'm getting at. Is that okay? Go ahead.
Okay. License 69757, it's a company that's publicly traded out of Texas, and they just have a new qualifying agent, but the new qualifying agent was a felony, no longer on probation, so I make a motion to approve that one. And then 71371, it's a HVAC to reciprocate from Alabama, father-son. The son has a felony, currently on probation. The father has taken the HVAC test in Alabama. So they're, make a motion that we approve upon receiving the new application to take the son off and list in the father's name only. That's all I have.
All right, I have two license application number 71369. It's a felony, Metro Construction Services, looking for a BC. Mr. Morrow, the applicant, had a non-violent felony in 2006. He served 10 months and then served probation through 2012. He's paid his full restitution, and I recommend we grant him a license in BC for $200,000. Another felony, 71087, green roofing and waterproofing, looking for $110,000 BCB. It was a cocaine possession in 2001. She served some time through 2005 and then 1 year's probation. She's been clean ever since and licensed in multiple states and has gotten a 4-year degree since then and just doing a really good job kind of getting things squared away. So I recommend that we grant that license as well.
Thank you. Chairman Keith, I think we could go ahead and, if y'all are approving the gentleman for the $350,000, I think we can go ahead and if y'all are still willing to
I just make a motion, we approve the,
we'll approve all those that we just went
all
over.
interviewed as requested.
Do I have a second? All in favor?
Aye.
Okay, thanks. We'll move along. Revisions?
I will move to approve the revisions.
Second?
Second.
All in favor?
Aye.
LLEs?
I'll make a motion we approve 41397 and 51401.
Have a second?
Second.
All in favor?
Aye.
Aye.
LLPs?
We had two. I make a motion that we approve license number 885 and number 3908.
All in favor? Second. Second? We had a second. Do we? All in favor?
Aye.
Thank you. Legal report.
All right, I'm just going to go ahead and read the case numbers into the record that were changed from the recommendation of council. Number 4, that is 2017-023-101. The board's decision is to authorize a civil penalty in the amount of $2,500 to be settled by consent order or formal hearing. Case number 5, that is 2017-027761. Board's decision is to close. Number 6, that is 2017-014671. Board's decision is to close. For case number 15, that is 2017-024471. Board's decision is to authorize a $2,500 civil penalty with formal charges authorized for violation of Tennessee Code Annotated 62-6-120D, which is unlicensed contracting exceeding $25,000. For 21, that is the one that I was requested to get more information on. Do you want to table that until?
Yes. Let's
Okay.
table it.
So 21 has been tabled until the end of the legal report. Number 22, that is case numbers 2017-018801 and 2. Board's decision is to authorize formal hearing against the respondent for unlicensed activity and allow authority to settle by consent order assessing $3,000 for unlicensed contracting in violation of Tennessee Code Annotated 62-6-103A1. Number 26, that's case number 2017-019531. Board's decision is to close. Number 33, case number 2017-028811. Board's decision is to close. Number 44 and 45, case numbers 2017-015391 and 2. Board's decision is to authorize a $1,000 civil penalty with formal charges authorized jointly against Respondent 1 and 2 for violation of 62-6-502A, which is unlicensed home improvement contracting. For number 46, case number 2017-019841, Board's decision is to authorize a $1,000 civil penalty with formal charges authorized for violation of Tennessee Code Annotated 62-6-502A, unlicensed home improvement contracting. Number 86, that is 2016-004662. Board's decision is to close with a letter of warning. For cases numbers 101 and 102, that is 2014-014671 and 2. Board's decision is to continue with the old recommendation for a civil penalty in the amount of $2,500 with formal charges authorized. And that concludes the changes on the legal report, other than number 21, which is case number 2017-021561.
I should mention that one additional 106, which is not on our agenda and pad, was added.
I'll do that into the record.
You got to do that?
Yeah, there was a commercial case that was added last minute. It was not on the original report sent out. Case 106, number 201703928, and that was about a bid dispute. And the commercial subcommittee concluded that the respondent was prohibited from being awarded a contract. If there are any questions about that, let me know.
Go ahead and tell us
Sure.
about table on 21 that we tabled.
So I was able to get, 21 is a company. I was able to get the owner of that company on the phone. I guess I'll read the description into the record since we're discussing. Complaint filed against respondent. The complainant was an electricity provider. Respondent is an electrical contractor. Complainant alleges respondent cut one of complainant's seals, removed the meter, and changed out a disconnect switch inside the breaker panel. This allegedly occurred at a residential address. The respondent failed to provide a response to the board. So when I reached out to the owner of that company, he said that he did receive a copy of the complaint and just did not respond. His explanation was that, so he pulled the electrical permit for that house, and he said that he did so at the request of someone from the State Fire Marshal's office, which I did confirm that the employee that he listed is an employee of the State Fire Marshal's office, because the house was without power. And this is not a new construction home. This is a remodeling project, I guess. So when he came out, he said that the meter had already been opened. So all he did was replace the main breaker. And the reason why he touched the meter at all is because the breaker in the house was broken, and I guess he said the meter was hot, So we had to disconnect the meter in order to replace the breaker in the home in order to get electricity back in this home.
That was a good response, but did you tell him that when y'all sent him a letter that he needs to respond?
I did, and he apologized. We still have the authority to penalize him for that.
Our marshal's here. Did y'all actually ask that to take place? Do you know? Yeah, please. Introduce yourself, by the way, I'm sorry. Some of us know who you are, but go ahead.
Gary Fogg, I'm the Director of Fire Prevention Inspections, State Fire Marshal's Office. Where this came about was the local power provider will send us letters, and we've had a number of those letters come in when these incidents occur. And what we do, we send them over to Carolyn, where they open up a complaint, and basically my Middle Tennessee supervisor told them they need to get a permit to have it inspected. That's what he does whenever we get the
He pulled a permit and that the electrical permit was approved, but I was not able to verify that. I haven't looked either way, though.
He's probably telling the truth since you've...
The lawyer called him up,
Since you twitched the alarm there. I think just go ahead and forget it. We're going to accept this $500 civil penalty that you, is that okay?
That's fine.
You've imposed, we have imposed a $500 civil penalty, and we will accept that if you would carry that out, and we appreciate you calling and getting to the bottom of it. Thank you. Okay. Right along.
We need to approve the
We
legal report.
need a motion to approve the legal report.
So moved.
Second. All in favor? Aye. Summary suspension status.
Well, excuse me.
I'm sorry.
Before you move on, Bill and I had talked about there's some confusion about which subcommittees are reviewing which cases.
Not only that, there's two things that I'd like the legal team, we need to decide. First of all, the residential committee has just overwhelming bulk of the legal report. So we were thinking that the commercial committee could at least take the LLEs and LLPs into our committee and consider those. And then we'd also like, I would like, to have a more manageable document to handle. For instance, you have the commercial original cases, and then you have the commercial represents in very different parts of the document that we receive. So what would be helpful, I think, is that we have actually two separate documents, one for the residential subcommittee and one for the commercial subcommittee, and put the residential originals followed by the residential represents, and then the home improvement originals followed by the home improvement represents, and then in the separate document for commercial, do the same for the commercial LLE and LLPs. It would be easy for us to handle and for us to review if we could do it that way. And then we could even, but so I would recommend to the board that we, first of all, lump the LLEs and LLPs with commercial from now on for subcommittee consideration, and then ask the legal team if they can to prepare a document that's easier for us to handle and review.
So in response to that, I did speak with our litigators about that. It would be kind of difficult for our process, because we have so many attorneys reviewing cases, to be creating two separately. I think what might be more manageable is if we found a way to reorder the sections of the legal report, so that if you are on one committee, you know that you are maybe reading the cases on pages 1 through 20, and then so on and so forth.
Good.
So maybe what we can do is we can talk about reordering the sections, and it has that table of contents on the front, and we can make sure that that matches up so that it's easier for you to know exactly what part of the report you're reading on, but I would urge that you allow us to keep it all in one document just for our own purposes.
I would be fine with that if the order could just be residential home improvement, commercial, LLE, and LLP, and then and put the originals and represents together on each section, then that'll work just as well.
We'll work on that, and as long as you guys are okay with the division of the subcommittees, I just wanted to make sure everybody was on.
I believe that's fine with Keith and I and Reese. Also, I want to say, we, again, appreciate y'all getting us the legal beforehand. And y'all are doing good by getting that to us. And again, thank you. Summary suspension status. Marty, would you like to start?
Yes, sir, I'd be glad to. After last month's meeting, we went out and started our investigation and going back and figuring out the big picture on the complaint for on Siebert's electrical license.
Would you kind of go over that, because some of our board members weren't here, that it'd be real good for them to catch up on this real quick?
Basically what happened was one of the deputy electrical inspectors in the Marshall County, Bedford County area received a complaint from the homeowner about their septic pump was causing problems and kicking something in the house that the alarm was going off. So the electrical inspector went out to see what was going on, and when he got out there, he got to looking in the panel box, and he noticed that the arc fault circuit interrupters that were required in the bedrooms were removed. And in his inspection documents, he always puts on there arc faults and GFCIs. If they're in there, he checks it off that they're there. I mean, he had that documentation on these permits. So what he did, he called his supervisor in Middle Tennessee, and the Middle Tennessee supervisor sent the West Tennessee supervisor in to look at this with him, and they found that they had been removed after it was approved, after the final inspection was done. Well, they got to going around the area in the subdivision there and found that there were 7 other homes that had the same thing to occur. And then actually went, after that, we got to looking how many permits this electrical contractor had pulled, and we got in our records over the last, since arc faults in bedrooms were required back in, since 2010, and we found there were 183 permits that, and addresses. Well, the board has asked us to go back and look at these 183. What we've done, we've sent out letters to each one of these areas, and there's multiple cities and counties that this has occurred in. We have found out, we've identified 139 structures, homes.
Already in this past month?
Well, we've identified some of the information we had. We couldn't get an address per se, because when they bought the permit, it was incomplete. Mm-hmm. But we've identified 139 of the homes. We've actually inspected 52. Out of those 52, we have found 5 more that this has happened to, with a total of 12 that we know of. Yeah, that includes the 7 that was on the previous complaint. Now, in this process, I've had 2 supervisors, one in West and one in Middle, performing this task. and it's been pretty time consuming. Right now at this time, and I'm having to keep up with their mileage and their hours of what it's costing us to do this, right now they have driven a total of 3,213 miles and they've had 135 hours in this. So what we're doing, we sent everybody a mailed letter, and they're going out door to door to each one of these locations, and they're leaving another letter there. And then some people are calling them back, setting up appointments to come back, and sometimes they catch them there while they go door to door. So we're canvassing the entire area, and actually it's Bell Buckle, Chapel Hill, Christiana, Columbia, Cornersville, Dixon, Lewisburg, Linville, Mount Pleasant, Petersburg, Shelbyville, and Tullahoma is where we're going. Electrical contractor. Yes, ma'am.
His company, it's a little bit more complicated than that. Yes, that's why I wanted him to go over it with you. Now, have you determined the young man that worked for the electrical company, have you determined, was he employed at the time of these other 5 that you have found?
Are you talking about the son of the contractor?
No, I'm talking about
The one that signed alleged that
took this.
I've not heard anything.
You haven't heard anything on that
We're
yet?
getting into questions now that will come out during the formal revocation hearing.
Okay. Well, I think y'all done great for this month.
I hate that it's taken this much time and expense for the state, but it's actually a safety and welfare and lives at stake. It has to be done.
Yes, sir, and that's why, I mean, my guys are diligently going out there and doing that to protect those citizens that are out there.
Contractor helping you by replacing these that have...
I've not seen or heard anything out of the contractor.
And that part of the discussion we had during the last meeting, that he was going to do that at his expense.
Cooperating with you?
When y'all found it, then he was going to go back. For instance, those 5 that you found, he was supposed to go back. My understanding that he was going to go back, pull a permit on those 5 of whatever you found, pull a permit.
Ronnie, he can't pull a permit. We've suspended his license.
Oh, I'm sorry. Have somebody else to do it. That's right. I stand corrected.
He actually pulled, his license was suspended after y'all got through.
Right.
He contacted another electrician. That electrician pulled a permit. His wife, Siebert's wife, went and bought it out of somebody else's name. She signed a check out of their company name, and then he continued to wire. And she signed the permit, and he continued to wire that job after the fact. The person that pulled the permit did not wire it. Mr. Siebert's son wired it afterwards.
I think we probably better stop our inquiry right here and right now, because this is going to come back before us, isn't it?
Okay.
All right.
I wasn't going to tell you that.
Yeah, okay.
You asked me, I'm not going to fit it in.
I understand.
What's your timeline? How long do you think it'll take to complete all of these? How many did you say? 100 and...
I'm hoping, we're wanting to notify these people
Yes, sir.
2 times. And once my guys completely go to door, that will be the second time they've been notified. We're not going to get all of them to call us back, because there's been some people thinking this, they've called us, our office, thinking there may be a scam, and we've explained to them what's going on. And we may not get people to call us back for appointments, but we're going to hit them twice, you might say, with the mail out and door to door. Yeah, we also notified the utility company not to sell any more permits to this gentleman. To be aware of what's going on, someone called.
We appreciate you coming up here and explaining, and we'll wait for further information. Thank you.
Seems like to me he offered to repair these, or why would we not go back to him and tell him, here
Mark, I hate to interrupt you, but this really is deliberation for the hearing. And I don't want to be rude, but it's gonna get us into some trouble if we deliberate too much right now.
Discussed at the last meeting, wasn't it?
Right, and that was a summary suspension. That was the last thing. But there is going to be a hearing, an actual hearing, where Lindsay's going to be the litigator, and it's going to be just like every other hearing that's before the board. So I just want to caution you between too much deliberation on, this is just supposed to be an update on the investigation.
That's what we were asking.
I know.
Our question, we felt like, was trying to get updated. We understand.
Opportunity to correct it.
Trying to hire somebody else. But I understand what you're saying. We're on the same wavelength, but I guess we're just going to have to move on this. It sounds like
You're asking if
litigation.
he's making efforts to make it right. I think that's beyond the scope of what we can discuss today in the meeting, because that's going to create significant
Asking if
conflicts.
The state is making efforts to contact.
My office is not.
Do you want me to answer that?
But Laura's my attorney.
Oh, if me first. Just to be clear, my role is disciplinary counsel. As of right now, this respondent is an adverse party, so reaching out to him to assist him in taking any corrective action would be outside the scope of my duties and also improper.
Our duty or your duty will come after the fire marshal gets through with his report to us, and then at that time, we'll be moving forward. Our concern up here is we're concerned about the health and welfare of the people who are living in these homes and how are they being taken care of. We don't want to be sitting up here saying that we know what's going on and nothing's happening. I think that's where we're going with this. And it appears we can't really get an answer because for some reason we got a conflict.
Does your letter and the stuff you outreach to these people make it clear to them the danger of not having these boxes correct?
State Fire Marshal's office in the letter that went out to all of the 139 homeowners lets them know about the danger of AFCIs not being in their home. The State Fire Marshal also has followed up. The 7 homeowners that were affected as part of the summary suspension have received a letter to let them know that those have been removed from their homes and to let them know that they may want to hire a licensed electrician to take care of that. So we are not letting them live in the home without being notified that there is an issue.
They know there's a
ones that are
danger,
affected.
that there is an actual danger, and they know what they need to do to fix
Yes,
it.
if there is an actual danger, if we have gone in and found something, those homeowners have received letters notifying them that the AFCIs have.
I think we're understanding what you're saying, but that's really not how we understood everything that's going to happen. And let me put it like this. I know that's not how I understood exactly what was going to happen. It appears Mark and I are on the same wavelength.
The contractor didn't even know this happened until 2 days before the hearing, basically.
It's 2 separate things. We have the State Fire Marshal's office and our electrical permits that we have a duty to notify and provide notice to those homeowners that that's not there. Because there was a final permit issued and it's no longer, we have to let them know. So that's our notice to cover ours. This would be separate as far as.
Right, so we've got the disciplinary action through the board, which I'm taking care of, and the reason for this update, I believe, how I understood it, was to determine when we want to set the formal revocation hearing, based off of how far along fire prevention was with their investigations. Their job is to notify the people to make sure that the health, safety, and welfare is not continuously endangered, right? They have, I do believe the respondent has your contact information, correct?
Yes.
So if he wanted to reach out, he could. He is aware that this is an ongoing investigation. Whether he has reached out at this point is outside the scope of what we can talk about in this open meeting.
Well, setting the date then goes back to the question I asked about when you think you're going to be completed with your canvassing.
I'm hoping that we should be able to be complete by the next meeting of your alls.
Well, if that's the case, can we do the revocation hearing at the next meeting? Or the day after the next meeting?
I've got to give 30 days.
That's 2 months away. It's a long time for somebody to be in danger.
They're going to do their canvassing. Everybody's going to be notified within another 30 days.
With these five additional ones that we've found after the fact, we're going to notify them in a letter, just like we did the other 7, letting the homeowner know that this has occurred and the situation, and give them the same advice that we did in the...
When do you think's the earliest we could do revocation hearing? Council?
It depends on, do you want them to go to all 139 of these houses?
Yes, of course.
So Director Farley is saying that he could get that done by the next meeting, but then I have to give an additional 30 days for proper service. So...
November meeting.
September.
So
September.
So the investigation could be done by the September meeting, right?
Now, we may not get to all 139 because they may not call us back. We're going to go door to door and try our best the second time to give them a handout. Now, they may not call us to come back, but...
What about the formal hearing in November, Ronnie?
I'm sorry.
The formal hearing in November.
He's suspended already anyway.
Right.
So we're talking about, as far as he's concerned, we're talking about whether or not to revoke.
Right.
Maybe impose some civil penalties. We don't actually have the authority to order mitigation or
That's correct.
So we can insist on that, demand that, hope they do that, but we actually can't make them do that. We can revoke their license or suspend it, we can impose civil penalties, we can flag them and all of that, but as far as making them make restitution or fix the problem, we can't actually. Oh, and you think we could have a formal hearing in November about the revocation?
Yes, I could set it for the day after the meeting. I believe we usually have those days reserved for a formal hearing, or even maybe the day of the meeting.
The afternoon, yeah.
Well, I think let's work on that assumption, and if something changes between now and September, you can let us know.
What would be wrong with contacting this contractor? And, I mean, at the hearing we had before, he offered to make restitution.
We can't compel him to do that. I mean, and we made that demand, and he said he would at that meeting, but whether he does it or not, we can't make him do it.
If we don't talk to him, he's not going to do it.
Well, we did talk to him at the last meeting, and he's not made any effort to do it that we know of.
What do we know? Can we contact him and ask him? And
I don't think we should.
I don't think we can even talk about this at this meeting, unfortunately. This is deliberation for the hearing. And we can't have this deliberation right now because he's not here, he hasn't been given notice.
We're really tying our hands up because we've got
I appreciate that it's frustrating, but what I don't want is to throw a brick in Lindsay's case.
Well, what's important is that as far as health and safety is concerned, that every one of these homes, and not just these 12, but every one of these homes needs to know that that was a possibility. And if they haven't been inspected, they need to be, that they understand the danger of it and that they understand what they need to do to fix it. And that's what your job is, and that's what you're doing. Is that what you're telling me?
Let's move on. I know we're frustrated and we've got some real other questions, but I hate that we can't answer it. So ask them. Let's move on to Go Bill. Thank you all again so much. Let's move on to Go Bill.
Afternoon. David McGowan. I'd like Susan Ritter to join us, just if she could. Okay. David McGowan, I'm president of Region Homes. We build about 400 homes a year. I'm also a director and vice president of Go Build Tennessee. We basically, the Home Builders Association, Road Builders Association, Association of General Contractors all went together and formed Go Build. And the main purpose is to ensure we have a good, stable workforce for the construction industry. And basically what we're trying to do is change the perception of our industry. Over the last years, with the computer generation and X generation, the Y generations, all these generations, the opportunity to go into the skilled trades basically had what I call a taint to it. People didn't see it as a place to make good living, didn't see it a place for a good job. This past year, we launched Go Build, and again, we have a fantastic board who represents all the different associations and all the different contractors that are out there. And we started a program that we launched, and we spent a lot of money. At the same time, we produced a lot of results. You should have received an email copy of the executive summary. If you look at this, the highlights of the executive summary, we basically wanted to show the opportunities that await young people who might want to get into construction industry. In 2016, it was estimated that 19,000 kids that graduated from high school could not find a job in Tennessee because they had no skills. And so what Go Build wants to do is we want to let them know that there's opportunities out there for jobs, but they need to go get the skills. And in our this past year, we developed all kinds of programs, information on a social media base. The generations that are graduating from high school today, they spend a lot of time on their iPhones and iPads and computer and with social media. So what we did, we built a database that enabled them to be able to go on that website and see different skills that are available and also request additional information and be able to figure out what kind of money they can make and who's hiring out there. It is estimated that for every 5 that are leaving the construction industry today, only 1 is coming in. And so if anybody who's in this construction business knows that we really do have a shortage of people working in this industry, and we need to get more people in the industry. If you go to the executive summary, you can see some of the things we've done. We basically, on our website, we've got 109 training programs that are featured on the website. We have reached 99% of the males between the ages of 16 and 24. We have grassroots events that we're doing. We have had over 40 events where we had job fairs and stuff. We have 8,000 students and individuals following us on our social website, and we've issued 150 toolkits to educators. You don't realize that in the past, when they had a college day for high schools, this industry couldn't really get in at high school. Trade schools and other applied schools couldn't get into the schools to be able to inform students that there's opportunities for jobs in the construction industry. Today we're able to do that thanks to what the state legislature has done. This past year we produced 22,000 TV ads to be able to, again, change the perception of our industry that's out there. We've done a lot of outreach. We've actually got young people who have joined and decided to go in the construction industry now that are serving as our ambassadors. And we've actually hired a grassroots coordinator as well to be able to go to different events to be able to sponsor Go Build and again change that perception. We're trying to also partner with people like the Venture Science Center to be able to have information in that science center where kids can be able to consider going into the industry. You think about it today, science is tied into everything, engineering and science both. And so with organizations like a Venture Science Center that we can tie into, we can actually be able to capture a kid's imagination at a very young age, something maybe in the elementary school, to be able to consider, hey, being able to operate a bulldozer or being able to be a CAD operator would be something that I would want to do in years to come. I'd like to ask Susan if she'd like to volunteer some of the information that we have there. You got anything you want to volunteer? The bottom line is we're off to a real good start. It's a lot of hard work that a lot of people put in, and again, we got a fantastic board that's doing that, and I'm here to answer any questions hopefully I can answer.
Anybody have any questions? David?
I could ask the board, have any of you seen any of the ads, the Go Build ads? I would say that our target audience is not y'all. We're going after students and the types of programs they watch, the radio stations that they listen to, or the sites that they visit. So I've not seen very many, and that makes me feel good because that tells me we're going after the right audience, and it's not us.
And I'd strongly recommend you go to the Go Bill site and go through the website and spend some time there. We have a lot of visitors goes there, and one of the things we're very proud of, that people who do visit our Go Bill site spend more than a minute at that site. And if you understand the generation we're going after, their average time on the site is like 30 seconds. So if they're spending more than a minute, they're actually going in there and looking for opportunities to find a job. Thank you.
Thank you, Susan, for putting us how old we are.
Ritter, yes, TTER. Thank you.
Let's move on to Home Builders Association of Middle Tennessee consent orders.
Tom White, WHIT, 315 Dedrick Street. Chairman, members of the board, my name is Tom White. I'm an attorney with Toon Entrican & White here in Nashville. I'm here to...
Tom, will you speak up a little bit more?
Start one more time. Can you hear me now?
Yes.
Okay. My name is Tom White. I'm an attorney with Toon Entrican & White here in Nashville. And I'm here today on behalf of the Home Builders Association of Middle Tennessee. I'll take less than 10 minutes with our request. Specifically, the request is that the board modify the consent order requirement that there be an admission of liability, and I'll cover the reasons for that very shortly. I've been involved in litigation with builders and developers and people that are subject to this board's jurisdiction for about 45 years. It's come a long way from where it once started, where basically all these cases were generally tried, whether jury or non-jury, normally in our chancery or circuit courts. As litigation became so much more expensive, there was a good judgment used that boards such as yours and others would be the sources of some arbitration and mediation, to the extent now where there's far, far less litigation taking place, and that's a good thing. It's far less expensive, it's the effective way to do it, and it brings some common sense to the procedures. The problem that we have here is that this board in part has a policy that requires not just people that are trying to get something resolved to use some common sense and get it done, but there's generally a requirement that there be an admission of liability in the process. Here's the problem with that. When you come through that process and you come through that issue where it's not just a good resolution, whether they fix the Brico block or they fix the brick or they do some other structural improvements, the problem is that there's basically a requirement for an admission of liability. What happens as a direct result of that is, some of you have been around in the construction industry a long time. It's a doctrine called collateral estoppel. And under collateral estoppel, once a board like this has entered an order where there's an admission of liability, that carries the day. You've got the same issue that would come up in any piece of litigation. So a builder could come subject to the jurisdiction of this board in all good faith, sit down here, resolve something as you want people to do, to avoid the hearings at the courthouse. It's not good for the industry. It's far less costly, and it's the effective way to do it. So what happens as a result of that with the admission of liability, all the plaintiff's lawyer does is file a suit, and basically the issue of liability is over. It's done. The only question is an issue of damages. So you go hire some damage expert and say they've already admitted liability, we're just here, and that could be a jury case or a non-jury case. A lot of times, this wasn't the case when I started practicing law, but a lot of builders now have got the requirements in their contracts that, has to be mandatory arbitration, has to be mediation. That often carries the day, but people that are smart about their time will come before a board like this and try to get things resolved. That's a really good thing about what this board encourages. But that admission of liability is just a killer when it gets to subsequent litigation, because liability is over. Could have been a very picky-unish thing that was the subject of the order here, but wide open liability is there. I've cited in a memorandum, which I was kind enough, I appreciate Carolyn Lazenby giving me the time to talk with her and send her this request in advance. In that same memo, I've given you citations to Tennessee Court of Appeals decisions where they basically stated that you don't have to have the admission of liability. And for boards, I gave two examples. One's the TDEC example, one's the Board of Podiatry, where they have requirements that it is not an admission of liability. Our Court of Appeals has said that's perfectly appropriate, and they encourage that because they fully understand that the admission of liability, once done, carries the day. It's collateral estoppel from that point forward. So I'll answer any questions, but I would urge the board to adopt a policy. You've got the total authority. You make your own rules. That someone consider making a motion today to eliminate the requirement in consent orders of an admission of liability. There's frankly no good reason for it, but the downside to it can be draconian. So I appreciate your courtesies in allowing me to come today. John Shealy's here as the executive director, but I wanted to get my comments out and ask the board. I know you can take it under advisement, and you can make a decision today, and I would urge you, unless there's some reason I don't understand why you ought not make a policy request today, that be taken care of. But thank you for your courtesies in allowing me the time. I'll answer any questions if you'd like.
Getting something up to present to us?
Mr. Tickle, I did in the proposal that I've had. Basically, the motion would be that the board's consent policy would not require an admission of liability. It's that simple.
John, this is brought from Middle Tennessee, I assume. And what is your...
So, I'm John Shealy with the Home Builders Association of Middle Tennessee. You have a case coming up, and I don't want to get into, but what's unique about it is there's a piece of...
You cannot give any facts about that case.
Okay.
I'm sorry.
Let me just, I'm not going to give any facts, but I'm going to say this. I had a front row seat to one of the pieces of evidence, and there's not the vetting. There's a higher standard in court. When you go to court, there's a much higher standard for approval of evidence, for redirect, for all of that. And I just, from that particular watching this thing go down, it's been going on now for quite a while. I think it's if you look at the enabling legislation that created the board, as far as testing people on their skills in the industry, financial wherewithal, and all of that, you have the power to suspend a license, revoke a license, fine somebody if they want to stay in the business. But then there's a certain point where it all belongs to the courts, and what's happening here is hobbling people who may or may not have been improperly vetted through this system, and circumventing their ability to defend themselves in court. And there's a lot to this case that I don't know about, but that one thing, which seemed to a lot of things hinged on, I know is incorrect. So.
And Mr. Tickle, I want to make the comment, I do not represent the individual that Mr. Shealy's talking about. It was the matter that brought this to my attention when I was asked. I've represented the Home Builders Association both locally and at the state level for in excess of 40 years. And I was really unaware of the policy about the requirement of the admission. When it was brought to my attention by John, I told him I had no involvement with the particular matter, and I appreciate the lawyer's role. I'm sure it's herding cats sometimes, keeping all of us away from certain issues. But mine has absolutely nothing to do with that. It's just basic good law, good policy that other boards have adopted. And again, I know no good reason why it should be required. It's going to intimidate from being in front of this board, which is the very thing you want them to do in a consent order.
This is interesting to me, and it's an interesting proposal. I don't understand all the workings of it yet, and I'm hoping that we'll maybe have a little more time to understand it. But one of the things I want to ask is I was under the understanding that most cases had already been litigated by the time they reach us. And if not, then we put a litigation monitoring stance on the case, so then that we're not making a decision that affects the outcome of that litigation. We're making a decision that's based in some part upon the results of that litigation.
Sometimes that does happen. Sometimes people do file civil litigation after, later down the road. Sometimes.
And I've been aware of that once or twice, and that's why I'm saying it doesn't always happen. That, yeah, we've had cases use our decisions, and actually, I remember one very large case. It involved another Middle Tennessee member, but you know, it's difficult. I don't want to take the teeth out of the board.
Here's part of the issue that I'll mention to you. I suspicion that in a number of cases the litigation may have taken place either before or concurrently when you're here. The problem is under Tennessee law, you got 6 years of a statute of limitations for a breach of contract. And so what will happen is someone could easily come before this board, have a resolution, and within a certain period of time thereafter, within the 6 years, the lawsuit could still be filed. And so unless the board policy is we're not going to have a consent decree unless the litigation's over with, and that's not the current policy, then this is an issue that could always be there because, again, people are going to be here in good faith. I'm not questioning the consumer, the plaintiff, or the builder. I think everybody's here in good faith as this board would want. But if the board basically says, we're encouraging that, we want it to happen, but there will be no admission of liability, what has not been accomplished? You've supervised, you've checked the builder developer, they've agreed to a reasonable resolution, and yet they're not opening themselves up for a subsequent piece of litigation, which can easily happen. Unless your policy says the litigation has to be over by the time you come here, and that's not your policy, it's over and they're wide open. So again, in trying to think this through, I want to be clear, I've said it twice, I have no involvement with the matter Mr. Shealy's talking about. That is what brought it to my attention. When I looked at it, I looked at the law in this area, which is, as I've said, the TDEC, podiatry boards, other boards have got this exact policy in place, which our Court of Appeals have not only said it's lawful, but have encouraged it because they feel this doctrine of collateral estoppel opens that builder up for whatever the limit of liability is. So again, I'm trying to persuade the board to adopt something today, but I want to say there's other lawyers here in the room. If somebody can think of any downside to this, they need to tell me. I just think it's that clear that there ought not be a wide open admission of liability that allows the person who entered into good faith in a consent decree to be subject to getting hit with an unlimited amount of damages later after the fact. Any judge, any chancellor or circuit judge is going to look at the doctrine of collateral estoppel and say, it applies here, period, which is exactly what our courts have said. And so they'll instruct the jury, if it's there, and bust. It's not a question of liability. That's all. And you folks have been there before when there's an admission of liability. It's wide open. At that point, it's over. It's just a question of damages.
You're saying the findings of facts are admission of liability?
Yes, sir. Yes. The findings of fact are perfectly fine. That's not an issue. It's the admission of liability that is the collateral estoppel key, in my opinion.
We need to hear from our attorneys.
Yeah, I just wanted to let him finish, but I did have a couple of points I wanted to put forward.
Before you do, I have something, I'll have to say, I'm not a contractor. I'm the public member of this board. And this is a consumer protection board. And I think that it would be wildly premature to vote to approve this today when we're only hearing from an attorney from basically a special interest of people who might be sued. And there are other opinions that ought to be taken into consideration from some kind of either consumer protection agency or perhaps the Trial Lawyers Association or someone who would have a different view of this. I would, as a public member who we all have an interest in protecting the consumer. I think in my position here, I especially have one from a non-contractor point of view, that to remove the admission of liability might not be in the best interest of consumers. And so I think it would be premature to make a vote today and would urge this board not to do that today. Of course, you can do as you choose as a group, but I hope we don't do that. And I hope we do seek out opinions that might, either concur or disagree with this kind of proposal from what is essentially one special interest in this matter. So you can, you know, before we do anything, I'd like to see us find out what other opinions are out there about it and what the downside to it might be from either parties who have a different interest or who have no particular interest in it with expertise in it. That I'm not an attorney, so I think that it would be worthwhile to hear from people with expertise that might have opinions that would be helpful to us in making the right decision about this. So I think we're premature to act today, and that we do need to seek out opinions other than this one that's been presented today.
I did get a chance to read the memo that was put forth by the HBA, and I went through and I read through some of the cases regarding consent orders where collateral estoppel applied, and in the Bacardi case specifically, a notice of charges had been filed, and there was, in fact, a hearing where there was live testimony. The same happened in the Morris case, which was cited. And the consent orders here, I'm not entirely certain that collateral estoppel would apply for a consent order by this board where there has been no notice of charges filed. I'm not sure that a consent order where it's being an informal settlement necessarily would, you know, for collateral estoppel to apply in Tennessee. And as you know, there's a test, and one of the prongs of the test is that the issue is actually raised and litigated. And I'm sure that an agreed order where a notice of charges has been filed, or where there has been a hearing in front of the board, I'm sure collateral estoppel would apply, but I'm not certain that a consent order would reach the level of an issue being raised and litigated on the merits, which is required. The other thing that I want to point out is that in some of these consent orders where there is no admission of liability, I mean, that can be used as a negotiating tool. For instance, in the Bacardi case, the podiatry board, the respondent, the podiatrist, his license was revoked. And I don't think that consumer protection is worried about an admission of liability to quite the same level when someone's agreeing to never practice that profession again in the state. I appreciate the position that they're coming from on behalf of builders, but this board in particular is here to protect consumers. And I don't know if the position that has been put forward has really viewed whether this policy promotes protection of consumers. You know, and to Keith's point, this does take, you know, this is an authority that you have, and it is the kind of thing that we could talk about maybe using as a negotiating tool a bit more often, but to adopt a policy where we are never going to require someone to admit liability, I do think would substantially harbor your own power that the legislature has given to you. So we do already kind of do this on a case-by-case basis, and there have been, it's exceedingly rare, but there have been times where we have not used the language that they are specifically taking issue with in consent orders. It's the kind of thing that you review with your supervisor. It's case-by-case basis. It's usually the kind of case where there was no harm to the consumer. There's just so many factors involved, and I think that if that's something that you want to know more about that process that our litigators use in negotiation, we can talk about that. But to completely cut off this tool of negotiation, I do not think would be wise.
But we already have the option or the to release from liability, or not have require an admission of liability. It's within our ability to decide that.
But we did recently on a case.
Our discretion.
It was the can I say the name since it's over the case? The Glenn Harris case. I think when they presented it to you all, instead of having you all go ahead and agree to the consent order instead of a hearing, part of it was that he didn't admit liability because he was still going through.
And that was an agreed order, because that was, if you recall, Dennis was the litigator on that case. He had filed a notice of hearing and charges against Glenn Harris, and Glenn Harris was agreeing to give up his license and no longer practice in the state, but he was in the middle of a criminal trial, and so when Dennis presented this settlement to you, that was part of the settlement offer. So it's not as if this isn't something that the board can use or hasn't used. I think that making this a blanket policy does not protect consumers.
If it's already within our discretion, I don't know why we give up our own discretion.
If y'all wouldn't mind just bringing something else to us next meeting, and then we'll discuss it, but I think Bill makes a valid point, and let's just see where it comes out.
I agree. I would like to see opposing points. I agree with the points being made, but I also want to hear the opposite point before I just make a broad decision.
Okay.
Thank y'all for coming.
I appreciate your courtesies. I might mention one thing that could be considered, and that is, I do think hearing from other people is certainly a very appropriate thing to do, and I'm not trying to say that shouldn't be done. I think it should be. I also mentioned this. What you could think about is adopting a policy that says that if you do require the admission, period, if you do that, there should be an agreement that there be no further legal action based upon that. In other words, if the matter's over at that level, you might be able to say, we want an admission of liability, period. But we have to have an agreement that it's not going to be used in a later judicial proceeding. It's just something to think about, unless that's what you intend to do. Maybe you intend to get an admission of liability and realize somebody's going to get set up for a later hearing, then make that decision. But you could decide, we want the admission of liability, period, for all the right reasons, the board's supervision, et cetera, but there'll be no further legal action based upon that. It's just a thought.
I don't appreciate that authority if you say it could go on 6 years later.
Well, if somebody, Mr. Tickle, if somebody in front of this board enters at a consent order where they basically say, here's what we agreed to, and we agree there'll be no further legal action based upon this, then they're stuck. Okay. That's an admission that would carry the day. But that's just something for the board to talk about, but that could be done. But if everybody agreed to it here, it would not be able to be raised in a later proceeding.
All right. Thank you. Thank you. Thank y'all. Appreciate y'all. Let's move on to Shelby County. Where is it? It's on the other side of the world. Carolyn, would you...
This is in your book, in your tab. Let's see. I had several questions, and I did draft some answers, but I wanted to get your all's opinion as well. Did you all get a chance to look at them? Okay. And one of the questions, did y'all want me to go through it and just, is it permissible for personnel of one firm to install electrical work under the supervision of employees of another firm, and does it make a difference if both firms are licensed? And of course, my answer would be is that, of course, the firm must be licensed. The firm should be the one who contracted with the owner, or if it's a subcontractor, contracted with the prime contractor, or it could also be a sub to sub. That happens a lot with electrical, but they would all need to be licensed. As far as, and this was something else in Fire Marshal's office has this with their permit agents, and they make sure that whoever pulls the permits gets a power of attorney or something from the company, and gives them a list of employees who are okay, or have been approved to pull permits. So I put in there as well is that they should get a written document from the licensee identifying the employees who may obtain permits on behalf of the firm. And then this is also covered under the permits portion of the electrical law, and it and it does go on to say that, this is under Rule 07800201, and it actually specifies who can pull a permit. And so it covers who can be pull a permit, and then it does talk about that the employee of a licensee can pull a permit. So that was going to be my answer for that question.
My question is, just by chance, are they asking that a plumbing firm install electrical work underneath an electrical license? Why are they asking this question? What are the specifics? Do we know?
I don't really, did you talk to them, Ronnie, when they?
Well, Ron said they're having problems, and this is some of the problems that they have, and then bringing it up to us to help us solve some of the problems.
And this is the electrical.
He's the head of the electrical division in Shelby County.
Yeah.
Ron is.
But I do know we've had questions before, mainly where they thought that it had to be the qualifying agent was the only one that can pull permits. And we don't have that.
Well, the question isn't pulling permits, it's installing work.
Yeah, I think it's more about the workers.
Oh, yeah, I guess it is more about the workers.
Firm is responsible for the employees. I mean, we don't govern the employees, right?
Right. We can't require them to be licensed, so.
Asking if it's in a bid situation and ABC Electric wins the bid, then they sub it out to Harry's Electric, and is that why they're asking? Is it a bid situation?
We don't know. It's coming from the permit agency, so I.
Permitting, not bid.
Yeah, no, that's what this is all about.
Okay.
Seems to me that what they're asking, the answer is that if you're going to put your employees under the supervision of another firm, that they ought to be working as a subcontractor for you. That the answer is you can employ a subcontractor if you want to, but it's a weird kind of question. It just sounds like that, well, I'm going to get the permit, but I'm going to use Joe from Smith's Electric Company to supervise my employees. And it seems to me if that's the case, he's either an employee of the original firm or a subcontractor. I mean, it's a really weirdly put question.
Yeah, I probably should have called her.
Company A can supervise Company B if Company B is a subcontractor.
Yeah.
Right.
That question's fine.
But if it's a bid
Licensed
situation,
contractor.
that's.
Gotta be
what is
licensed.
that
Definitely
different?
licensed.
Yeah.
Both
In
firms
situation-
have to be licensed.
You prefer they be knowledgeable
It's the
too.
same.
They're not talking about their
But
employees.
Company A could have all the knowledge and just instruct Company B how to do it.
The second part of the question suggests that who they want to hire is an unlicensed company, which wouldn't be acceptable.
Right, because.
So the answer to part B would be, yeah, they both have to be licensed.
Right.
And then the other company has to be operating as a subcontractor.
Licensed.
Exactly. Both companies have to be licensed, and one of them has to be operating as a subcontractor.
Hope you'd have to be operating as a subcontractor because
Or as employees of the first
Yeah.
company, one or the other. You could hire somebody away from another
The
company.
second question, is it permissible for electrical contractor to utilize employees of a staffing agency for the installation of electrical work? Electrical contractor would still be in control of the temporary employees, so.
when they have to have some
I agree.
knowledge of doing electrical work though. I'm just,
But you wouldn't hire someone, if you're an electrical contractor, you wouldn't hire someone to do electrical work under you that didn't know what they were doing.
It's up to the company
It's up
itself
to the
to hire
company
people
to
that are
determine if,
We don't.
I'm not saying it's not happening, you're giving me that look. I'm not saying it's not happening, but I don't think we can police that.
okay.
Mark made the point that we license companies, not individual employees.
In the The last question, is it permissible for a licensed electrical contractor to pay her workers as independent contractor?
Unless they're licensed.
Unless they're licensed.
Unless they're licensed, then we hire them as a sub.
They have to be licensed. Yeah.
This is a dodge, an illegal dodge to avoid your responsibility for employees. Payroll taxes or workers' comp, or stuff like that.
Yeah.
And that's what they run into every day. They'll name every single one of their employees as a subcontractor, but none of those have a license.
They got to be licensed. Well, that's good. If you would respond to Ron, I would appreciate it.
I sure will.
So I won't have to tell him to call Kathy.
Yeah, I struggled with number one. I think I put more into it that needed to be, and it's basically, yes, they both need to be licensed, the firm and the subcontractor.
We have the updates on the formal hearings, legislation, and budget, Carolyn.
We had over 9 formal hearings scheduled between May and this meeting, May through July, and we ended up having 3 hearings, and the rest of them were either settled or continued. And I do know from looking at my calendar, they have got a formal hearing scheduled for 1 a week in September, and I believe in August there's actually 3 in August. So they're scheduling them. So most of them, the judges are waiting and not making a decision right away, so we still don't have what the findings are. But usually it's always the maximum. They'll do the $1,000 unlicensed penalty. So, and then this is our budget update. I meant to email these to you, but. Right now, it just shows, in my books, we have $657,918. And that's after expensive, that's what we've got right now. Oh. My sheet notes. There's not really any legislation right now to update. We haven't heard of anything being drafted.
Since you've given this budget out and how much money we have, I've been asked by our board to again request new books, which we've supposedly been granted that we could have. And it appears that we've had some questions today where we needed reference, and we didn't have it in our book. And we need those books. And with what we have in the key, there should be no reason for us not to get our books. So if you would please get our books from the new commissioner, since he came to see us, and the assistant commissioner now are going to ask him to do us what we've been asking him to do.
And I'll put in the request, and it'll be around $14,000. So,
would you like a roll call from the board?
Do I need?
We have enough of those. Instead of spending $14,000 to publish one of these, what if we publish 10 of them and each board member gets one, and the public just needs to go online and look at them?
The $14,000 is a flat fee to print one.
Oh, got you.
Yeah.
Is this that we might as well get every how many?
Is that a single source contract?
That you have.
Yes.
It's a single source contract.
Yes.
Carolyn, what about the book
LexisNexis.
that you have? Why couldn't you just copy that book for us?
I could, but it's horrible. I mean, I could copy this for you all, but
Let's just go ahead and get our books.
Does someone keep the website current?
Yeah, it's current, it's always current.
What?
Well, they don't have it so you can print it, you have to print it one page at a time, and it has a lot of other junk in it. I mean, I could print it, but,
Wouldn't be a user-friendly document.
right, it's not user-friendly.
Mark, we really need a user-friendly document.
That's going to be out of date as soon as you print it.
Not as out of date as what we've been walking around with.
That's true, but
Yeah, 2007. But, I mean, we'll try and print it and see what y'all think.
Let's just, can somebody make a motion, we get new books? Can I have a second?
for $14,000, that's just not, in my opinion, necessary.
When these books are not just for the use of 9 board members, who else uses these books?
County codes officials, they call wanting them all the time.
So that would be helpful. So
Right.
We would provide a book to all 95 county officials.
Right.
In addition to us.
Yes, we
And
can get 1,000.
And to maybe associations or other people that might need this.
Yeah, we can get 1,000 books for $14,000.
I move that we authorize $14,000 for the production of new law books.
Could I have a second?
But can we amend that? That was the last,
I move that we authorize whatever is necessary for the production of new law books.
Now can I have the second?
Second.
All in favor say aye.
Aye.
Any opposed? Let's move along. Any more new business? Or any new business?
Yes.
Okay, there you go. The sleeping giant over there.
I have been offered a position to be a policy director for Brian McCormick, and I am going to be taking that position. So there is going to be some staff changes. I'm not leaving this department, and you will probably still see me at quite a few of your board meetings. I'm working on legislation and policy and rules and all that stuff. But because I will still be here and working with rec boards, I'm very committed, as is the department, to a very peaceful transition. And I just wanted to let you guys know at the end of this meeting, I've really enjoyed being your attorney and working on this board, but this will be my last meeting where I am your program attorney. Thank you.
We just got you trained.
I know.
Never fails.